This season of Trucksafe Live is presented by LogRock. LogRock builds technology tools to help trucking companies stay compliant with federal and state regulations. LogRock is easier. We connect to multiple systems like your FMCSA account and ELD, so you only have to use one system. LogRock is faster. We automate tedious tasks so you can use your time more effectively. LogRock is smarter. We notify you of issues like expiring or missing documents before they happen, so you can be proactive rather than reactive. Setup is easy, and most of our customers are online shortly after signing up. Request a demo now at logrock.com.
Hey everyone, welcome to episode 27 of Trucksafe Live, the show where we and our guests tackle the hot button issues impacting highway transportation. I'm Brandon with Trucksafe and Childress Law, both of which are dedicated to helping motor carriers develop and maintain cutting-edge safety programs. Today's show, we are talking about meal and rest breaks, a topic I thought we were done with in this industry, to be honest with you, but we are being dragged back into it for reasons that elude me. Not sure what we're doing here, but here we are. So it was breaking news earlier this week and worth talking about for sure, particularly if you're a fleet that has drivers in operations in California and or Washington State. So that's what we're going to talk about today. Before we get there, a few things going on. Always something going on over at Trucksafe. First up, I'll mention our upcoming Fleet Compliance Boot Camp. This is going to take place in Orlando, Florida, October 12th and 13th. 2-day conference, in-depth DOT compliance information, conversations, networking with fellow safety professionals. That's what we got going on. We did one of these earlier in Indianapolis. Went very well. Got a lot of great feedback from it. So we're going to do this again in Orlando, and then we're going to try and do it twice a year, every year thereafter. So if you're interested in joining us, we've got just like 1 or 2 spots left open. We're already pretty much full. But if you're interested in joining us, hope to see you there. You can check out the details over at trucksafebootcamp.com. Aside from our boot camp, also wanted to mention our Trucksafe Fleet Compliance Network. This is something we've always kind of got going on in the background here, but this is our online social network for safety professionals. It's free to join. If you haven't already joined us over there, be sure to do so at trucksafenetwork.com. We also have an app available. That's what we're showing here in the App Store and the Google Play Store. It's a space for safety professionals to gather together, ask questions, learn from one another, and also gain access to all of our DOT-related content, our videos, our articles, network exclusive webinars. We just did one of those a couple weeks ago. We try and do them periodically on particular areas of compliance. Our last one we did was on building out defensible driver safety policies. So anyway, check that out over at trucksafenetwork.com. We hope to see you there. Lastly, about Trucksafe, I'll just mention our newsletter. If you're interested in receiving breaking industry news or our analysis on various issues, including things like what we're talking about today, FMCSA's notice on meal and rest breaks, check out our newsletter, trucksafe.com/subscribe, and we'll send that over to you. We send these out pretty regularly. Like I said, a lot of analysis, a lot of breaking news, that type of stuff, all kind of geared around or focused on DOT compliance. So check that out. All right, anything going on in the industry aside from our topic for today? Not a whole lot over the last couple of weeks. I did notice, and it's worth pointing out, that Pipeline and Hazardous Materials Safety Administration published a notice last week or so about 200 or so cargo tanks, I think they were MC 300s and 330s, that it discovered were not properly inspected. These are cargo tanks that were, I believe, manufactured by the Meter Equipment Company in Fresno, California. Anyway, FMCSA conducted an investigation and found out that around 200 or so of these cargo tanks had been inspected by someone who wasn't properly certified to conduct those inspections, so they all have to be re-inspected. So if you are using these tanks, then you have until November 10th to get those re-inspected. You could check out more information on those. I don't know how many fleets out there are using these tanks, but significant enough for FMCSA to publish a notice on this. But you could check out more information on FMCSA's website. Again, that's the Pipeline and Hazardous Materials Safety Administration for the details. All right. So that's all I've got going on, Trucksafe and what I wanted to talk about going on in the industry. So let's segue into today's topic, which again is the notice published by the FMCSA in the Federal Register earlier this week. This is August 2023 when we're recording this. That notice invites the public to file waiver requests from the agency's own 2018 and 2020 decisions, where it had held that California's and Washington's meal and rest break rules are preempted by the federal hours of service regulations. Anyone who's been in this industry for any amount of time knows about the huge legal battles that have been and continue to be fought in California and Washington concerning those states' labor laws and their applicability or inapplicability to commercial drivers operating through those states. One major aspect of those cases are states' meal and rest break laws, which the FMCSA, again, determined previously that those laws were preempted and unenforceable, at least against interstate regulated drivers. But the agency's notice earlier this week has the potential to once again upend our understanding of those laws and their application to commercial drivers. So that's what I wanted to talk about on today's show. I'm grateful to be joined once again by my good friend, transportation attorney, CEO of the Grawe Group, Grawe Group law firm and independent contractor status guru, Mr. Doug Grawe. Doug, thanks for joining me.
Thanks, Brandon. Happy to be here. Happy to help out.
Doug, I have one question for you, and the question is WTF? That's the question that came to my mind immediately when I saw this notice come through. So that is my question to you. WTF? What is going on here?
No kidding. I'm not going to lie. I didn't have this on my radar as something the FMCSA was going to bring up either. I'm not going to say that some of the trade associations hadn't been talking about it, but I had missed it if they were, that this would be coming up. Since it is come out, you start going down the rabbit hole of what are they thinking? Why are they doing this? And so forth. And I am not one of those people that sits there and thinks that Joe Biden is sitting in the president's chair and dictating every last little thing that every agency under his thumb is doing. He's not doing that. That's impossible. But you do have to think to yourself that anytime anybody starts to take over new agencies, Secretary Buttigieg or the acting FMCSA director, she's confirmed now. So
she's confirmed now.
Yeah, she's Robin Hutchinson. You are thinking about legacy and what you can get done while you're in control. And doesn't matter what the polls are saying or not saying, anytime you start approaching re-election time, which we are fully in re-election time, you are thinking to yourself, okay, what do I need to get done but just in case we lose and I lose my spot? So somewhere on a whiteboard in somebody's office in the FMCSA is a list of things they want to get done. And someone wrote down on that whiteboard, I want to get rid of the Trump era preemption ruling that they made on California and Washington. And somebody looked at the calendar and said, oh crap, it's August. We got to publish this.
You would hope on that whiteboard at the FMCSA that you would see a bunch of safety related stuff and not politically driven stuff. But I couldn't help, when I saw that notice came through, the first thought in my mind was this is completely politically motivated. This issue has been settled for 3 to 5 years now. And there had been back and forth even back then, and we'll talk about that in a second, but it had been settled. This is what we were used to. This is what we knew in our industry for at least the last 5 years. And so now we are, and what was incredible to me is the way that this was done. It's an invitation from the FMCSA for the public to file waivers from their preemption decision. I have never seen the FMCSA do something like that, where they issue a ruling and then they invite the public to request exemptions from that ruling.
Yeah, they're standing on the street corner, waving and jumping up and down, saying, "California, Washington, please ask us to reverse this because we can't wait to reverse this." I'm never going to say they've never done this because I haven't been around forever, but I'm like you. I can't think of another time when they advertised they want to change a rule and asked people to help them do it by saying, "Please petition us for an exemption."
For an agency that always complains about being short-staffed and not having time to do what Congress tells them to do, to imagine a situation where they are inviting more work on themselves on an issue that has already been resolved is just absolutely crazy to me. But
you're exactly right. But then again, stuff would have to make sense, and that's not a rule with anything that comes out of the agencies. It doesn't have to make sense. What's frustrating about this? Well, there's a lot of things that are frustrating about this. But to your point about this was settled. Not only was this settled in terms of the preemption argument was settled, but we just revisited hours of service. You know better than I do exactly when hours of service all got revamped, but it's kind of like we did a lot of work, a lot of litigation as an industry to come up with better hours of service rules. You're better at speaking about this than I am, but I think the current rules are pretty good. And to think this is another way of the FMCSA saying we actually don't like our hours of service rules. We think California is better at it than we are.
Yeah. So 2019 was the latest major revisions to our hours of service rules, coming on the heels of the ELD mandate in 2015. We had pretty substantial changes to the hours of service rules in 2019, and these were changes that were pretty widely heralded in our industry because they gave fleets and their drivers some much needed flexibility that was absent before these changes took effect. Namely, they revised the current rest break requirement that is built into the federal hours of service regulations. So before 2019, we had a rest break regulation, a 30-minute rest break regulation that said that a interstate regulated truck driver had to take a 30-minute rest break within the first 8 hours of coming on duty during his day. So anytime within the first 8 hours of first starting his or her work for the day, he would have to stop for a 30-minute off-duty rest break. Well, that was all well and good. But then in 2019, in addition to some other changes that gave additional flexibility, the FMCSA saw fit to change the way that we did rest breaks. And what they changed it to, and what is currently the rule under the federal regulations, is that the truck drivers now only have to take a 30-minute rest break once at any time before they have accumulated 8 hours of actual drive time. So it used to be tied to when they first started working during the day, but now it is tied to drive time. So you don't have to take a 30-minute rest break unless and until you have accumulated 8 hours of driving time. The idea being that what they need rest from is the activity of driving. It's the monotony of the driving activity that causes the fatigue and necessitates a rest break. Not so much the paperwork or the office work that they may be doing at the start of the day. You know, maybe you have drivers out there who work at a warehouse for 6 hours at the start of their day, and then they only drive later in the day. Well, we're not so concerned from a rest break perspective for those folks as we are for the drivers that have been sitting in the same seat for 8 hours straight. So that's what changed in 2019. That's how our current rest break rule works. In addition to that change, we also changed it so that now commercial drivers can accomplish that 30-minute rest break with a combination of off-duty and on-duty not driving time. So it used to be they had to be completely off-duty to accomplish that 30-minute break. Now they can accomplish it with a combination of off-duty and on-duty not driving. So, for example, driver pulls over into a gas station and goes and is getting fuel, which is going to be on-duty not driving time. They're not driving, but they're still on duty. They're doing some work. They're fueling up the vehicle. Previously, that time couldn't count towards their 30-minute rest break. But now they're not driving anymore. They're doing something else. They're out of the truck. They're moving around. So we're going to count that time and any off-duty time. As long as it's 30 minutes, then that gets them the the rest that we were concerned with. So that has been the rule since 2019. That's the rest break requirement. And so that kind of takes us in then to what exactly is going on here. And my question to you is, maybe we could talk a little bit, because this is going to be critically important. If these waivers are granted, then we're thrust back into a point where, in addition to that federally required 30-minute rest break, we could have not just California and Washington, those are going to be the first states to do it, but presumably we could have every state in the country come up with their own meal and rest break requirements. And if you've got drivers in those states, then you're going to have to comply with those rules potentially. So let's talk about California's and Washington's meal and rest break rules. What are they generally, and how do they apply?
So California's requires a second. There's two issues that California and Washington meal and rest break rules do that are more stringent or more cumbersome or hazardous towards carriers and drivers compared to the federal rules. The first is, like you alluded to in your comments, it's a little bit more going back to, we are going to dictate when you take a break based on when you start your day, as opposed to based on how much you're driving or how long you've been doing a certain task. It's back to, okay, you start at noon, so between 2 o'clock and 6 o'clock, you have to take a 30-minute break. And then if you work beyond more than 6 hours, you work 10 hours, then between it'd be about 5 o'clock and 10 o'clock, you've got to take another 30-minute break. So it's going to be more restrictive and more specific in prescribing when you have to take a break. And it's also going to require that you take a second break. Washington's there's some nuanced differences, but it's essentially the same thing. It's prescribing not only when you have to take the breaks, but also that you have to take a second break. And the way California and Washington work, now I would argue it's probably good practice anyways for carriers to be engaged in ensuring that drivers take breaks. But in California in particular, it's not enough to say, Joe, by the way, you can take your break whenever you want to take your break. You have to make sure every day Joe takes his break. And if Joe doesn't take his break, there is no defense of saying, here's the email I told Joe he could take a break. Here's the phone call when I called and told Joe he could take his break. If you don't make sure Joe takes the break, you are responsible and you're liable. And it's that combination of putting you on the hook for policing every minute of your driver's life, plus the prescription of when and where they take breaks, that make this less safe and more cumbersome for drivers and for trucking companies. And like you said, with these two states doing it, you can see others following suit. I live in a state that loves everything that California passes. So I'm assuming at some point in time, Minnesota would like this rule too.
Yeah, and the other thing to point out is, California's and Washington's meal and rest break laws are applicable not just to truck drivers. These are broadly applicable laws to all workers within the state. And so they're not designed specifically for trucking, obviously. And so that has been the big, from what I could tell, the big impetus for our industry really getting up in arms about that, is that those laws, they may work for an office worker who can easily go and take a break, go to the break room and, get some coffee for 10 minutes when the clock hits those times. But if you're in a truck, you're out there operating on the street, it's not like you can just pull over wherever you're at and take a 10-minute break. I mean, you may be in the middle of the city, and now your clock's up, and now you've got to take your second break. It takes time, and it takes effort, and it takes availability, parking space, to be able to make that happen.
You're right, and I can see now our audience is typically going to be people who are living and breathing trucking all day long. But I'm picturing someone who doesn't know trucking hear what you just said, and they're like, okay, so it takes them 5 minutes to find a parking spot. No, it does not. It takes hour at best, sometimes 2, 3, 4 hours to find that trucking spot. So okay, so if I have to do 2 breaks within that 10 hours. Okay, and it's going to take me at best an hour each time to take that break. I'm looking at 3 hours I'm losing during the day to either on my break or having to get to a place where I can take my break. By the way, that's time just driving around or idling and more pollution in the air.
And that finding spots is not accomplishing the break. That is still on duty work. That is work. And so it's not like you get to count that time that you're trying to find a spot as the required break. Once you get to the spot, that's when you could start your break time.
Yep, spot on. So you're right. They're rules designed for quote unquote all employers, and you're right that they serve a perfectly good purpose for a lot of industries. I'm not going to say trucking is the only one that has its own issues and unique issues that should exempt it from these rules, but trucking is definitely one of them. I'm picturing a planner and a dispatcher and a driver trying to work together. The dispatcher and the planner are based in Iowa. The driver lives in Tennessee. He operates nationwide. So every couple of weeks, everything's going to have to get adjusted because he's got to load through California. There's a lot of things that have to get adjusted to deal with one-off issues in California and Washington. This is not an easy thing to manage.
And to this point, we've only talked about meal breaks. So in addition to the meal breaks, there's also a rest break requirement. So you got the 30-minute meal break requirements. You said two potentially in a 10-hour period. And then California and Washington also have a 10-minute rest break requirement for as I understand it, for every 4 hours, you have to have a 10-minute rest break requirement. What I don't know the answer to, I don't know if you know the answer to this, Doug, do the 30-minute meal breaks count as the 10-minute rest breaks, or are those in addition to those 30-minute meal breaks that you have to take?
My understanding is they are in addition to.
Okay.
So I'm not going to argue that I do a ton of work in Washington, California, but that is my understanding.
Yeah, that was my understanding as well. And it's consistent with FMCSA's previous preemption determination, where they said that if California and Washington are allowed to enforce these rules, that truck drivers in those states would have to take 3 times the number of breaks that they are required under the federal hours of service rules, which would be right then. You would have the 2 meal breaks in that 10-hour period, and you would have the 1 or 2 potentially rest breaks as well. So it's huge potential change here.
With all that same parking challenges so now I got to spend an hour to take hour finding a place to take a 10-minute break.
Yeah, exactly.
Let's talk about efficiencies, huh?
Yeah, no kidding. So let's walk through kind of backing up. We kind of dug right into it there, but looking back at kind of the history of this, and I tried to kind of lay it out at the start, but this is not a new issue. This has been resolved and looked at many times in the past. So maybe you walk us through kind of where this all started, where we've been in terms of FMCSA's action or inaction on the topic, and how that got us to today.
Yeah, so the FMCSA first issued an opinion on this issue of whether or not a state, and specifically California at the time, whether California's meal and rest break rules could be enforced against an interstate truck driver. Okay, knowing that the interstate truck driver is already governed by the federal hours of service and all the federal safety regulations. In 2008, a group of trade associations in the industry and carriers in the industry petitioned the FMCSA for an opinion, a ruling, on whether or not California's meal and rest break rules were preempted under federal law by the by federal law. So the FMCSA ruled in 2008, unfortunately for the industry, that no, they were not preempted. Now, I think it's critical to keep in mind that in 2008, we had different hours of service rules. And when we get kind of later on in the history, we'll explain a little bit more about why that's significant, but it is significant. They were different rules at the time with not, frankly speaking, as many rests in there and not as prescribed of rest break options and requirements for drivers. And
yeah, I don't think we had a rest break requirement at the time.
Exactly. So I think you and I would both agree the existing rules are better. They're better
Correct.
for safety. They're better for operations. They're better today than they were in 2008. But in 2008, the FMCSA said, no, these are not, California's rules can take effect. Fast forward to 2018, and the American Trucking Association, coupled with a couple other trade associations, California Bus Association, and some others that I know I'm forgetting, but a handful of trade associations that all deserve credit for it.
I think Specialized Carrier and Rigging Association was part of that.
Yes, I believe you're correct. Petitioned the FMCSA again in 2018 to revisit this. One of the things they talked about a couple of things that differentiated it from 2008. I'm not ranking these, but one of which was a case out of the Ninth Circuit called the Dilts v. Penske case, which talked about this issue. And the Dilts case kind of signals, in its opinion, while the Dilts case in general is not a good case for trucking, what it does signal in its opinion is, because the Dilts v. Penske case had to do with local delivery, kind of some final mile stuff. It didn't relate directly to over-the-road truck drivers. And the Dilts court essentially says, hey, California's rules apply and they're not preempted by federal safety regulations. But they signal in there, we're not making this opinion based on over-the-road driving, which may be different. Okay? I'm not saying that's what tipped the trade associations off to let's go petition this, but I think...
But you can understand why, because, over-the-road truck drivers, the concern then becomes differing rules in the different states through which they're passing versus local drivers, which are just, one state, one set of rules potentially.
You're exactly right. So 2018, the FMC, the ATA and these other trade associations petitioned the FMCSA to look at this again, and arguing, hey, we've got this Dilts case. So you can see how this is impacting the industry, and this is a trucking company that is now going to have to dealing with California's meal and rest break rules as well as the FMCSA rules. So we got a real life carrier being impacted by this. 2, truck parking has just gotten exponentially worse in 10 years between 2008 and 2018, and I would argue it's exponentially worse today than it was in 2018. Okay, then you've got the hours of service rules change. And also, and you'll know better than I do exactly when the ELD rules went into effect. You've got the hours of service with the new brake rules coming into effect, and now you actually have ELDs, which are dramatically increasing compliance with hours of service rules. So the ATA and other trade associations are arguing, hey, this is not a safety issue. This is entirely a labor and employment issue, though, that is impacting safety. And it's hurting carriers' ability to comply with the law, and it is hamstringing drivers' ability to make safe decisions out on the road. It is taking power away from the drivers to do what is good for them from a safety perspective. In 2018, the FMCSA agrees with the ATA and grants the petition and says that California's meal and rest break rules are preempted by federal law. Okay, so we've got a 10-year stretch here. 2008, bad decision for the industry. 2018, good decision for the industry. And when I say industry, I'm not just talking about trucking companies. I think that's good for drivers, good for safety, good for the public, good for a lot of things.
Oh, and by the way, there has been a change of political parties between those two decisions. 2008 to 2018, right?
Yes and no. 2008 is the first petition is still issued under W.
Oh,
That's
okay.
George W. Bush.
Yeah, you're right. I
That's
was
the
thinking it was
end
an
of George
Obama
W.
era.
Bush. Yep. He comes into power in 2009. He wins the 2008 election.
Okay, so
but
was
he
this
comes
still
to
a
power.
Republican appointed? So this was still a Republican appointed FMCSA administrator at the time.
Yes.
Okay,
Yes.
and then in 2018, then we have a Trump appointed
Correct.
administrator. Okay.
Correct. So the Trump administration does it. Fast forward then to 2020, the Washington, a couple of Washington trade associations make a very similar petition. Now, I don't want to lump California, Washington together in the sense of saying they're the exact same thing, because there are differences between the two, but in the grand scheme of things, the logic, the arguments are pretty much the same. But a very similar petition goes to the FMCSA relating to Washington and its preemption, or the preemption of Washington's meal and rest break rules. And for similar reasons, using similar logic, the FMCSA grants that petition. So since 2020, we have had two specific. It's not a rule making. That's not the process. What it is it's a petition for a ruling or a determination or a decision by the FMCSA is granted in favor of saying the federal safety regulations trump / preempt these California and Washington meal and rest break rules. That's where we've been for 3 years. And like we started the show off with, we were all surprised that apparently this was on their radar to blow back up.
So since 2020, then California and Washington have been unable to enforce their meal and rest break rules against interstate regulated drivers, is essentially what it comes down to. And correct me if I'm wrong, but since that time, those rulings have been tied up in court cases. Is that right? So some groups have challenged the FMCSA's preemption determinations in federal court.
Yes. In some ways, I do always feel sorry for agencies, just in the sense of no matter what they do, they're getting sued.
Yep.
It doesn't matter what determination, what ruling they make, they're going to get sued by somebody. That is one of those things. It's not alone in being the Teamsters that challenge them, but the Teamsters, the states themselves, some other trade groups have been litigating and challenging the preemption determinations by the FMCSA.
But those have been upheld to this point.
That's
court has struck down the preemption decisions.
That's correct. The good thing is there's a statute out there that really gives the feds a lot of leeway when it comes to saying that something is preempted. And the way this rule works for in trucking as it relates to safety regulations, there is a law, and if anybody really wants it cited, 49 USC 31-141. If you really want to nerd up and go read it. But the gist of the law says, hey, if the Federal Motor Carrier Safety Administration, if there are already regulations on the books related to safety, okay, it's going to look at a state rule and it's going to say, okay, is this state rule about commercial motor vehicle safety? And the arguments against the preemption usually focus on that first point. Is it about commercial safety? And California and Washington are always going to argue, hey, these rules are not about commercial motor vehicle safety. They're about labor and employment rules for all employees. This is not
generally applicable labor laws, is what they always say.
Exactly. And like I said, you and I have already discussed a little bit about how that's not really accurate. But the first threshold issue is this about commercial motor vehicle safety? Then after that, then you start to look at, okay, is this regulation or law from the state less stringent than the federal rule? Is it as stringent or is it more stringent? Okay, if it's less stringent, pretty easy, not enforceable. The federal rule trumps. Okay, we always want to hold the trucking companies and the drivers to at least the federal standard. Okay, then if it is equal to, Okay, it's enforceable because it's the same rule. Okay, those two are pretty straightforward. The third one is, what if it's more stringent? Okay, if it is more stringent, then you start looking at, okay, is this going to be how does this impact safety? How does this impact commerce? Okay, what are the other impacts of this rule? And usually what's going to happen is you're going to say this is going to be preempted because it is going to be such a burden on interstate commerce, or while it may have some safety benefits in one spot, it actually has an overall worse safety impact. And this is a classic example. We've already talked about it. It's that truck parking thing.
Yeah. So this is the analysis that FMCSA undertook in its 2018 and 2020 decisions. It ruled that, number one, California's and Washington's meal and rest break rules are laws on commercial motor vehicle safety. We're not going to get into the details of that. They essentially say, hey, it governs the same content as our hours of service rules, so it's going to be considered a law on commercial vehicle safety. They then progress to the next step, determine that those rules are more stringent than the federal hours of service rules, and so then it is up to the FMCSA administrator to determine, I think there are three factors that would render it potentially preempted. If you meet any one of those three, then it's going to be preempted. Number one is going to be, does it benefit safety? I want to make sure I get these right. Hold on, I got these. Do you have these written down too?
Not compatible.
Not compatible with the federal law, and then an undue burden on interstate commerce. If any one of those is true, then the FMCSA administrator can rule that it's preempted. And the interesting thing here is that in those decisions, FMCSA found that all three were true.
Yeah, and I will say is, there were we talked a little bit about which administration was this. There were things issued by agencies under the Trump administration that I would say you read them as a lawyer and you're like, I don't know if that's the strongest argument that I've ever seen. These preemption determinations were very well written and very well argued. They built that case very well, and you're right. They only needed one, and they clearly spelled out why all three apply.
Supported by studies on truck parking, on driver fatigue, on burdens on data that they got on the potential burdens on interstate commerce, including decreased efficiency and additional cost and lost time. All of that was baked into the FMCSA's analysis, and they ultimately concluded back then that, yeah, these laws are preempted and they're not going to be enforceable.
What was great about those answers is, as someone who does, I do just a touch of lobbying in my practice and help some companies and some organizations out with making comments to the FMCSA and to other state and federal agencies from time to time. It was a great example of the power of comments. Now, don't get me wrong. There's a lot of times when a proposed rule or a proposed rulemaking comes out where you can kind of read the tea leaves of what's going to happen. I'm not going to argue that that doesn't sometimes happen. But what those determinations showed you is when the trade associations took on the heavy lifting of the legal arguments, we're going to cite the cases and the statutes and the legislative history and all that kind of stuff. The trade associations are great at that stuff. Okay. But what the companies did, what the drivers did, was they gave real life examples and real life data, and the agency used that data to back up why the parking issue is a real issue, the burdens on interstate commerce are real, and so on. So I hope our listeners take that home and realize speaking up matters. It may feel like you're spitting into the wind, and sometimes you are, but you never know when your comments, when your data might get used. So I encourage you, speak up.
Yeah, for sure. And especially if FMCSA is going to give the public the opportunity to weigh in on these waiver requests that they are soliciting. I've said this in some of the posts that I've made, and I believe this to be true. The FMCSA would not be actively soliciting these waiver requests if it doesn't fully intend to grant them. So I don't think there's going to have to be much of a showing made by California and Washington to get the FMCSA to grant these requests. But if they are going to give the public the opportunity to weigh in, which I think they should, I don't think they're required to under this law. But if they do give the public the opportunity, I highly recommend that the industry come in hot and heavy with their comments. I have no doubt that the ATA will and the American Bus Association will. They've already expressed their displeasure with FMCSA's action in this, and so I expect that they will, on behalf of the industry, submit their data. But any motor carrier out there with operations in those states should be submitting comments if they are given that opportunity, for sure.
They should not just. You're right that the FMCSA has signaled where they're probably going to go, and I can see a listener going, well, then I'm not going to waste my time. Waste your time, because it's not wasting your time, honestly.
Yeah.
Because it also gets used in the litigation. I'm not an expert of some of the procedural rules that go into how agencies can and can't do some things, but I do know there are rules about what they have to do with comments, how they have to take them into consideration. And I do know that it gets brought up in the litigation of, well, you disregarded, comments, 1 through 1,476 that all spelled out this type of data, this type of argument. So do share your story, do share your data when they ask for that public comment. And you're right, I don't think they had to, but they've signaled they're going to ask for public comments. So we've got to be ready.
I hope that they do. And, it's kind of a unique feature of this particular federal law. Sometimes when you see preemption legislation, like F4A is a prime example. If something is preempted under F4A, it's just preempted. It doesn't give any discretion to the agency to make the determination of whether it is or not. But this particular law, 49 U.S.C. 31141, actually gives the FMCSA administrator the discretion to accept petitions for preemption, rule on them, which it did here, and then also to accept waiver requests. And that's kind of what brought us to this most recent notice, is that, normally you don't see this. If somebody has determined that a state law is preempted by federal law, then the federal law just trumps the state law, and that's the end of the story. You don't see people be able to request waivers from that preemption decision. But that's what's unique about this particular federal law, is that it gives the FMCSA explicitly the authority to accept waiver requests, and that's what it's doing now. I don't think Congress envisioned FMCSA actively soliciting them on them unprompted, but that's what they're doing. They're taking advantage of that last part of that legislation, which says, hey, even though you agency have determined a state law to be preempted, you can accept requests for waivers from that determination, and there has to be certain showings made for you to be able to grant those waivers. So kind of looking at this for the future. So FMCSA has solicited these requests. I fully anticipate California and Washington will submit those requests. Their departments of labor will probably be the one, or their attorneys general will submit those requests. And in FMCSA, they're asking for those states to address particular questions. You want to run through those real quick?
Yeah, so it's as an aside, I have to think to myself, I assume that California and Washington did know this was coming. Otherwise, I'm picturing someone in the Attorney General's office in Washington going, well, now I got to do what?
Merry Christmas to us.
November 23rd to do it. Yeah, so they are, yes, you're right. Washington, California, either directly or someone on their behalf will submit these petitions. The FMCSA has signaled that they want the petitions to address, and I should be looking at exactly what it is, but it's parking. They specifically want feedback on parking. They want feedback on whether or not, and whether or not the California and Washington rules impact parking and how parking interacts with those rules. They want to know what kind of burden it adds to trucking companies and to drivers and to agencies and administrators. They're going to be looking at that side too, for enforcement and what enforcement of these rules look like. Poor me, I didn't bring up the list of all three.
I got them here. So the first question is whether and to what extent enforcement of a state's meal and rest break laws with respect to intrastate property carrying and passenger carrying has impacted their health and safety. So
Yes.
they want to see both sides of this. They want to see, hey, do the states have data that their inability to enforce these rules has negatively impacted workers in those states? And then on the other side of things, they want to hear about industry concerns. Tell us about the parking shortage and what you states intend to do about that, if that is a problem. And then also tell us about how this will, they say, here's the third question, whether enforcement of a state's meal and rest break laws will dissuade carriers from operating in those states, and whether any such effect will weaken the resiliency of the national supply chain, and whether the applicants, the states, intend to take any action to mitigate or address those effects. So they know that these are going to be concerns, and they want the states to address them, because this is inevitably, like you said, going to end up in litigation.
Yeah, and the frustrating thing is that, and I share this with people a lot of times, is all of us will bemoan California and what they do, and rightfully so. It is still like the fifth largest economy in the world.
Yeah.
So I hear a lot more talk of we're going to leave the state than I see action. I'm not going to say I see action. I do definitely see people leave the state of California, so I know it happens. But I probably hear about it more than I actually see it.
Yeah.
So that is going to be a little bit challenging. I do encourage those that have left California or intend to leave California, please do speak up when that happens, because that will be powerful, powerful stuff.
Yeah.
The other thing that I anticipate from California and Washington is, especially when you go back to that first question, that health and safety of the drivers and so on. What I anticipate will happen is we'll get just a little bit of data from the states. But I think back to the USA Today article. That's probably a 10-year-old article of the rigged expose, which
the port
I'm not
drivers,
say,
right?
Yeah, the port drivers. I'm not going to. We all know there are bad trucking companies. There are bad truck drivers. There are bad, financial brokerage companies. There are bad schools. There are bad whatever organization. You can pick any organization, pick any trade, and there are bad actors in it. That article chose to, we're really going to pick on one or two bad actors to make an industry look absolutely abhorrent. And I fear a similar type of arguments will come from California and Washington, is they'll find a bad actor and they're going to tell a graphic story, a very tug at your heartstring stories of some people whose health and safety have been negatively impacted by the inability to enforce California meal and rest break rules. I don't think it'll be heavy on data. I think it'll be heavy on, here's a sob story for you, which will probably be a true story, but I think that will shade their arguments a lot in what we have to come back with data about as an industry.
Yeah. I'm cynical, but I don't think there's going to have to be much of anything included in those waiver requests for them to be granted. Like I said,
Agreed.
I've just never seen FMCSA solicit these, and because they are doing so, I have to think that they just intend to grant them. That's why they solicited them. But we'll wait and see. We got a couple questions here before we wrap things up. That time flew by there. Brian is asking, and this is a question I have, and I can't. Maybe you don't have the answer to it, Doug. I'm not quite sure how this works, but how would the rule be enforced once a driver crosses the state line? Does the time start then, or did it start when the driver came on duty originally? So I guess the broader question is, how would this work if California and Washington are able to then enforce their meal and rest break rules? Does it apply only to California resident drivers or to drivers that just happen to be operating in there? How do you see that playing out?
So it's a great question. It's a question that gets asked on a lot of California's rules, whether you're talking about ABC test and independent contractor status, or you're talking about meal and rest break, or any number of different California labor rules. So there's not actually, for as much litigation there is around this, there's actually not been a ton of clarity brought to this. What is absolutely clear that courts agree with, that I think, all the industry agrees with, is that the driver lives and operates primarily. What everybody's definition of primarily is a little bit gray, but let's just say use a reasonable determination of primarily. If they live and work primarily in California, they're going to be subject to these rules, even if they duck into Arizona for an afternoon. If the person lives in Nevada or Arizona or Oregon, but regularly comes down into California, daily, weekly, something along those lines, these rules are going to apply. There is actually not much definitive, there's been district court, but we're talking about Court of Appeals, Supreme Court kind of stuff to say, when do some of these rules apply to a true over-the-road driver that lives in Illinois and hits California once every couple of months? What I can tell you is California thinks their rules apply the minute that guy hits the border. So if he hits the border halfway through his day, California is going to argue we govern the whole day.
Yeah.
That's what they're going to argue.
You calculate your time from when you started working, even though that was in Nevada or Arizona or whatever.
Correct. I think California is wrong. And I think, and so that if I'm a carrier, you just have to figure out, okay, well, how much am I fighting that? How much am I litigating that? I think my personal opinion is the way the law works is, if the guy or gal is not primarily operating in California, regularly operating in California, some kind of threshold along those lines, the California rules do not apply to him or her.
That's been my understanding as well.
Yeah. But
to your point,
don't underestimate California thinks its rules apply to everything.
Yeah, just look at CARB and all the other rules. So, yeah, it's hard to say. I mean, it's one of those things we'll have to wait and see. But it's hard to tell a carrier that is trying to plan out how this is going to affect their operations. So I think if FMCSA is going to do this, we need to come up with a plan to let fleets know that have operations out there how this exactly is going to work for them, because FMCSA is ostensibly also working on the truck parking shortage, but now they're going to enact, or they're going to take action that's going to have a negative impact on their own work. It's just, there's several reasons why this is just crazy to me. Things just do not make sense.
We talked about this at the beginning. The Federal Motor Carrier Safety Administration should be focused on safety regulations, not doing the U.S. Department of Labor's work.
Exactly. Let's see here. A couple more questions. Some of these may not be related. Let's see what Angela's saying here. Angela's saying, question about short haul, 30 minutes. Do we have to take them, or no? Can my job force me to take them? Short haul exemption kind of plays into this analysis a little bit, so it's worth talking about real quickly. Short haul exemption is an exemption baked into the federal hours of service regulations that essentially says that if you're a driver that stays within a 150 air mile radius of your normal work reporting location and you don't work more than 14 hours in a day, then you are exempt from the onerous driver logging requirements, the record keeping requirements, the ELD requirement. It does not exempt you from the hours of service rules except for the rest break requirement. So short haul drivers, if you meet those criteria, are exempt from the federal 30-minute rest break requirement completely. So that is an interesting question is, okay, we got these short haul drivers that are operating maybe into California. They're still within 150 air mile radius of their normal work reporting location. They're normally not subject to any rest break requirement under the federal rules. Now they are going to potentially be subject to 3 different meal and rest break requirements.
So what you'd have to think about is if you're a carrier, if this preemption, if these waivers get granted, which I'm with you, I'm pretty sure they're going to, you're going to end up with a 2 grids on the wall. Okay, what are my California rules, or my Washington rules, and my federal rules? Okay, which one is more strict in this scenario? That's the one I've got to follow.
Yeah,
and you're just going to go down the line of all of the rules. Whichever one's more strict, I got to follow.
And that's exactly what federal preemption is designed to avoid, is the so-called patchwork of state laws on a particular topic that result in interstate businesses having to evaluate the differences in the laws in all of the states that they operate. That's the point of federal preemption. That's why the FMCSA determined this to be preempted in the first place, and that's why it is so frustrating and confusing to us as to why we are contemplating going away from that and back to a patchwork of state laws on this particular topic. So anyway, any closing thoughts, Doug? Anything we haven't hit on this topic before we wrap things up here?
I feel like I should have some words of wisdom, 10, but I'm not sure I really do. I always applaud trucking companies. The hits keep coming. They always do, but I'm still awfully proud to be a part of this industry because I know the good work we do every day. And yes, this feels like another hit. We'll keep fighting back on it. We're not going to take this one laying down and keep fighting the fight.
Doug, where can people find you if they have questions for you or want to reach out?
Yeah, go to the website, www.thegrawegroup.com. You can email me, Doug.Grawe, my last name, Grawe, at thegrawegroup.com.
All right, Doug, thanks as always for joining me. Really appreciate your insight on this topic and all kinds of topics. If anybody's interested, Doug and I have done prior shows in the past on independent contractor status. We had a discussion about AB5 when in the Supreme Court's involvement in those issues. So go back and check out those episodes if you're interested. But anyway, thanks again, Doug. Really appreciate you joining me. All right, so that's going to wrap up the show for today. Appreciate everybody joining us and participating with us. Very interesting topic. We will continue to provide updates on any developments on this issue, particularly when we get waiver requests that are filed. We'll let you know. We'll send out newsletters and stuff like that. So stay tuned. Follow us on our social media pages. That's where we publish our most timely information. So you can follow us on LinkedIn, Facebook, Twitter, YouTube, all of those channels. Stay tuned for our next episode of Trucksafe Live. We try and do these a couple times a month. You can find details. You can watch prior shows on trucksafelive.com or wherever you happen to get your podcasts. You can subscribe to us. Thanks again to the sponsor of this season of Trucksafe Live, LogRock. Appreciate you teaming up with us to make this possible. That's all I got. Thanks everybody for joining us. We will catch you next time.
Thanks, Brandon. I think it went okay.
Yeah, that went really quick, and I think we got everything in, so really appreciate it.
I didn't know you have drivers that listen in. That's
So our YouTube channel, so we this goes live on LinkedIn, Facebook, YouTube. Our YouTube channel, we've got like 7,000 subscribers now, and most of them are truck drivers. Because
nice.
we do a lot of content on how to understand the hours of service regulations, stuff like that. So we do have a lot of truck drivers that listen in. So
awesome.
Anyway.
Awesome. Good work. Well, let me know if you ever need anything else.
Will do. Thanks, Doug. Talk to you later.
Thanks. See ya.
All right, bye.
Bye.